the understanding, which I would describe in my own mind as having evolved over the understanding, which I would describe in my own mind as the fact that not only can the impacts of abuse be profound and long-lasting, but that they can be very different for different people.
You haven't made any effort to read the literature or take any course dealing with these matters?
No.
And if you had done, as the Archdiocese's principal solicitor on sexual abuse matters, you accept you might have given different advice in regard to causation?
I've very rarely been called upon to give advice on causation.
Well, I'm talking specifically about the advice we were looking at before the short adjournment in the Foster's case, where you raised a doubt as to the link between the abuse and some of the effects that were said by others to be as a consequence of the abuse.
Yes, I think to the extent that I was perhaps sceptical of some of those matters then, if I had known then what I know now, I would have been less sceptical.
And had you read the literature, you might have had a different view back then.
I might have. I can't comment as to what the state of the literature was back then either.
Now, reverting to the matter of the release of the confidential information, you'll recall you referred to an interview that the Fosters had with Professor Ball.
Yes.
The transcript we have is in relation to an interview on the 29th of July, 1997. I'm not aware of another one. Are you aware of another one?
Sure. Be corrected, but I stand to be corrected. There are two.
Well, those acting for you, have just given me a transcript dated 12 March 1998. That's perhaps the second one you're referring to.
Perhaps.
Now, I want to move on, Mr. Leader, and deal with the question of the Fosters, that is, Mr. and Mrs. Foster being dealt with as secondary victims. And if we can have a look at tab 140. And here you are writing to the Independent Commissioner in September 1998. If we can scroll down, the heading is in relation to Emma Foster, and in particular in the second paragraph, you say, after some discussion, I take it that's Anthony Foster, made the comment that the compensation payment was intended for Emma. I said that this was correct. He asked about other members of the family. I said that generally speaking, compensation was only available to so-called primary victims. I explained that the law recognized that in some circumstances a person could have a claim arising out of physical injury, although they had not been physically injured themselves. I gave the example of a mother who witnessed her child being run over and suffered nervous shock. I said that consideration had already been given to the question of whether he and his wife were victims, and that as I understood it, Peter O'Callaghan's view was that they were not. I understand from that that was also your view.
I look at not necessarily. It was for Mr. O'Callaghan, who, as well as being Independent Commissioner, was also a clearly very experienced senior counsel to make that legal decision. I don't know that I turned my independent mind to that question as opposed to knowing that that was his view and holding the position that as independent commissioner, that was for him to decide. I don't.
Well, this letter records you having justified or explained to Mr. Foster the basis for them not being recognised under the scheme with reference to the common law.
Yes, I was seeking to set out the legal position and the question at law, which was effectively the nervous shock question, of which I don't claim to be expert. And as I said there, I obviously could not speak for Peter.
Well, now this scheme, of course, was set up on the basis that there's no acceptance of legal liability. It exists separate from whatever legal liability there may be, not so. So why in those circumstances is there reference to the law as opposed to reference to the terms of the scheme itself?
I think because in the scheme itself there's no definition of victim, and therefore it fell to the independent commissioner to determine who qualified as victims and who did not.
Well, that raises two questions. One is the terms of the scheme, and the other one is assuming that there was no qualification for secondary victims, whether, as a matter of policy, the scheme should be changed. I'll come to the second one in due course. Dealing with the first, if we can have a look at tab 36, which is the independent commissioner's terms of appointment. And we have a look at towards the foot of the first page, you will see there's a definition of complaint. It means any complaint made to the commissioner by a person that he or she has been abused by a church person, or a complaint made to the commissioner by a person who complains that some other person has been abused by a church person, and any complaint of abuse by a church person which is referred to the commissioner by any other person. So a complaint certainly would include a complaint by someone who was not themselves abused.
Yes.
And if we scroll down it slightly further, you'll see there's a further definition which you'll see it again. It says, obviously an error, it says complaint means any person making a complaint of sexual abuse, as aforesaid. That should be a complainant.
Complainant, yes.
Complainant. So a complainant would include someone who wasn't necessarily themselves the subject of sexual abuse.
That's right.
Yes. And then if we look at the terms of the scheme at tab 13, starting at paragraph 1.4, it says in this plan, a complainant is any person making a complaint of sexual abuse against a church person, and an accused is a church person against whom an allegation of sexual assault is made. Of course, it's perhaps not quite as clear as the other definition of complaint and complainant, but it certainly doesn't exclude the possibility of a person who was not themselves the subject of sexual abuse being a complainant.
Yes, I agree.
And then if we have a look at paragraph 4.1, which deals with compensation, that's on page 5. A compensation panel will be established to provide ex gratia compensation to complainants of sexual abuse by accused church persons. And then it goes on, functions of the panels to provide complainants and so on. I mean, you would accept from those terms that they're certainly wide enough on their face to include secondary victims.
I can see that argument, and as I recall, it fell to Mr. O'Callaghan to form a view about that, and he formed the view of which we're aware.
And as the church's solicitor, you at that time were obviously aware of the view that he had formed.
Yes.
And was that then an issue that was addressed by you with your client as to whether that was correct, either as to a correct view or as to whether it was right that this scheme should exclude secondary victims?
As to whether it was a correct view legally, if I can put it that way, I don't have any recollection of discussing that with the Archdiocese. As to the intention of the Melbourne response, the intention when the Melbourne response was established was that compensation be available only to primary victims. So the view that Mr O'Callaghan formed was one that I felt reflected the intention.
And on what do you draw to state your understanding that that was the intention?
That's my recollection, and I think it's, and I'm of course speaking of the views that were held back in 1996, but I think it's reflective, again, of the position that there was no legal liability. The establishment of the Melbourne response was seen as novel and the first time in the world that this had been done, and the view formed was that in relation to ex gratia payments, that they were available to primary victims. That was the view held back then. But that was, you know, in determining the ambit of people to whom assistance was being provided, that was the view.
The foster family, of course, is a stark example of a whole family being devastated by the effects of child sexual abuse. I agree. And the Hirschbeck family is perhaps another example of the effects on the family wider than just those who were themselves subject of abuse.
Yes, I agree.
And you will understand, of course, that this is a matter which will have to be grappled with in any possible future redress scheme as to how far it can go.
Yes. And I would make two comments, if I may, sir. First, that between 1996 and now, the law has expanded the definition of, or expanded the concept of who can make nervous shock claims, and that provides a signpost for what I think the Church should do. And secondly, regardless of the developments of the law, I think that these schemes, that assistance ought to be provided to secondary victims as well.
Now, moving on to deal with perhaps another systemic issue which is illustrated, at least in the Foster's case, and that's the one of the Foster's claim for accommodation for Emma.
Yes.
Perhaps we can look first at tab 166. And you'll see that this is a letter from Anthony and Chrissy Foster to the then Vicar General Monsignor Pross, dated 2 April 2003. And they say that they've been advised by Ms. Elizabeth Harding and Professor Ball to write to the Vicar General with their request, as they, being Ms. Harding and Professor Ball, are unable to be of assistance. And then they say, as you are aware, our daughter Emma Foster was sexually assaulted by Father Kevin O'Donnell. And they go on, and then in this next paragraph, because of Emma's long history of depression, self-harm and substance abuse, we are no longer able to care for her in the family home. And then they go on and outline some of the difficulties that that's created. You saw that letter at that time or shortly thereafter, not so?
Yes.
And then at 167, on the 11th of April, the Vicar General, Monsignor Pross, in fact at that time it would appear Bishop-elect Pross, wrote to you and said, I have received today a letter from Christine and Anthony Foster in regard to their daughter Emma. The letter is self-explanatory, and attached is a letter in support from a family therapist, Nikki Maheras. Do you see that?
Yes, I do, yes.
And your advice was then sought on, well, if we scroll down a little bit further, the paragraph at the bottom of the screen, I would be most grateful, Richard, if you could advise the Archbishop on the directions indicated above. You may even wish to draft him a letter if you are in agreement with such direction. And that's in relation to what is to be done with the request for assistance for accommodation. Is that right?
Yes.
Yes. Now, I'll show you, Mr. Leader, a copy of the report from Nikki Maheris that was referred to.
Is it in the bundle?
It isn't, Your Honour.
Well,
we're getting copies to you right this minute, Your Honour, and to the bar table.
and what about the screen? Can we put it on the screen?
Yes, we can, Your Honour.
You want to tender it?
Yes, Your Honour, I do tender it.
We'll make it Exhibit 16-8.
Now, it may be a while since you've seen this letter, Mr. Leader, so I'll just give you an opportunity to familiarise yourself with it. You'll see that Ms. Maheris starts off by saying, "I write in support of the enclosed letter forwarded to you by Mr. and Mrs. Foster," and she sets out who she is. And then in the second paragraph, she says, "Emma has experienced sexual abuse perpetrated by a Catholic Church priest. This abuse has occurred over a prolonged period, commencing as early as age 6. Disclosure about the abuse did not occur until after Emma, as a teenager, became a patient of a mental health service, showing symptoms of anorexia, substance abuse, self-harming, and suicidality. These symptoms are present in nearly all cases of survivors of prolonged sexual abuse. Treatment of such symptoms is made more difficult if patients are not stabilized and secure in supportive accommodation. The abuse creates a lack of safety, and a lack of safety in other situations exacerbates the symptoms." And then she goes on and she says, "Emma has not been able to maintain her accommodation within the family home because of these symptoms and their impact on family relationships. To preserve these family relationships and to ensure that Emma does not become cut off and socially isolated from vital support networks, it has been necessary for her to leave home. Her parents continue to provide emotional and practical support in a way that can be more useful to Emma from the position of living away." And then going on, "Although her homelessness has resulted from a series of crises, including an overdose, leaving home has also been an important transition for Emma in regards to maintaining the normal life stage developments of independence and autonomy. However, because of the specific characterizations of her psychiatric disability, it has not been possible for Emma to be placed in suitable accommodation that caters for her special needs. Some of her special needs are outlined below." And then, indeed, Nikki Maheris goes on to outline those and some of the difficulties that have been faced in acquiring accommodation for Emma. And that's the letter that was given to you with the facts from Bishop-elect Price seeking your advice. Is that right?
I believe so, yes.
If we can go back to the Bishop-elect's facts, which is at tab 167, you'll see in the second paragraph that's currently on screen, he said to you, "I have discussed the matter with the Archbishop. He is aware that we have already assisted this family in the tragedy that has unfolded. Such assistance may be said to be more than reasonable and generous given our parameters." What do you understand the parameters to have been that the Bishop-elect was referring to?
The sorts of assistance that were provided through the Melbourne response.
So effectively the terms of the Melbourne response scheme.
Yes.
Yes. They certainly weren't affordability parameters.
No.
Essentially, your advice was being sought on where to draw the line between what should be provided for and what's not provided for.
Yes. Yes.
If we have a look at tab 168, is your response on the 15th of April 2003. If we scroll down, you'll see it references the facsimile of the 11th of April that we had just had a look at.
Yes.
And you record that some weeks ago you had been rung by Professor Ball and Elizabeth Harding to discuss Emma Foster's situation, and in particular the issues relating to her accommodation.
Yes.
And in the next paragraph, you say, my analysis was that to the extent that Emma had accommodation needs that were therapeutic and were part of a program of treatment that was finite in time, one could justify meeting those costs through CareLink. It seems to me that just as CareLink would arrange emergency residential treatment of someone who was suicidal, or might arrange respite care for someone with particular difficulties, there was ample justification in CareLink arranging for Emma's accommodation at a detox or drug treatment facility. So that's, in a sense, one side of the line, as you were putting it.
Yes.
And then you go on, however, beyond that, it is quite clear that it is not CareLink's role to provide long-term accommodation for anybody.
Yes.
And that's how you saw the line being drawn. Was that particularly with reference to the terms of the scheme, or as a matter of policy for the church?
I don't know that I see a distinction, really.
Well, the distinction might be this, that if the terms of the scheme were quite clear, one way or another, the question might arise as to whether they should be different.
Yes, well, in the sense in which you're putting the question, that's how I understood the line to be drawn within the terms of the scheme.
And then you go on in the next paragraph. The request from Mr. and Mrs. Foster does not suggest that there is any link between Emma's need for accommodation and any treatment that she requires. And then you say, rather, she is homeless because her parents have thrown her out. I take it you accept that's not a fair characterization of the situation as it was.
I do. And I apologise for using that language.
We can move on and address the litigation. As I understand it, in July 2003, you received service of writs in the suits by...
Just before you do that, Mr. Stewart, the next sentence, or the next paragraph, you offer an opinion contrary to that that's provided by the counsellor's letter, as I understand it.
Yes, I do.
Do you think it was right for you to do that?
I think that what was really being asked of me, and what I was seeking to say there, was that it was my opinion at that time that the link between Emma's homelessness and the abuse was too remote. I think that's what I was being asked to express an opinion on, and that was the opinion that I expressed.
The only evidence you had was from the counsellor, wasn't it?
Yes.
And that clearly created the link. How could you offer a contrary opinion?
Well, looking, sir, at the letter from the counsellor that refers to various factors and expresses an opinion, a professional opinion by Ms. Maheras, I was seeking to express a legal opinion about remoteness, which may or may not have been correct, but that's what I was seeking to do at that time.
The only evidence you could base that on was the counsellor's letter.
Yes.
How could you therefore come to any contrary conclusion? It wasn't a legal question, it was a question of fact.
I didn't see it that way, sir.
Well, that's what remoteness is, isn't it? It's a question of fact.
And yes, and sir, as I would understand it, looking at whether there are relevant intervening events or not, and I think that's at the time, the view I felt was that, the view I formed was that there were too many other things that would be going on in one's life to be able to draw that link. It's not a view that I would necessarily hold now, but I think that was the view that I held then.
Well, it's not a view that gained any support from the only evidence you had, which was the counsellor's letter.
That may be so, sir. Yes.
Well, it wasn't right then, was it, to offer that view at that time?
Perhaps it was not, sir.
Now, Mr. Leader, I understand that in July 2003 you received service of writs in the suits by the Fosters.
Yes.
And some time was taken up in you acquiring instructions to act on behalf of all 6 named defendants, is that right?
That's right, yes.
But ultimately that became the position.
Yes.
And thereafter statements of claim were filed and served in each of the actions.
Yes.
And the statements of claim came to be amended.
They did.
And what I intend doing is, and I'll take you to them in a moment, we'll go to the amended statements of claim and as they ultimately appeared. If we can look at tab 175. This is a file note of yours, is it?
Yes, it is.
And that's your handwriting.
If that's what it can be called, yes.
And the matter in respect of which it relates is RCC and Foster, is that right?
Yes, it is. Yes.
And this records, does it, a telephone call from Archbishop Hart?
Yes.
I suppose the Archbishop was probably returning a call of yours.
I don't know, but probably.
But in any event, the subject of discussion was the case and in particular the defences, is that right?
I think the subject of discussion was the fact that legal proceedings had been served. And yes, how they would be defended.
Can you assist us with your writing by just reading out what is written there?
Yes, certainly. It says, take the defences, and then on the next line, medical examinations early.
Right, and can you briefly just explain that telephone call and what the significance of those 2 notations is?
Yes, I can. I would have to say first that I don't now have an independent recollection of the conversation, but I believe that the discussion that I had with the Archbishop was that the various defences along the lines of those that we discussed yesterday would be taken in response to the claims that were put. And I believe that we also discussed the fact that in relation to the allegation of abuse itself, in the statement of claim, the details were very scant, and that there would be various ways through the proceeding to draw that out, and that what was proposed was that it would be, or that I probably can't assist with the context except to say that we discussed the fact that for the plaintiffs to undergo medical examinations in order to get an expert opinion, an expert report, that it would be helpful for that to occur earlier in the proceedings rather than later. So the reference to medical examinations is a reference to seeking expert psychological or psychiatric opinion in relation to the plaintiff's claims.
And although the note is not dated, I understood you to have identified that this telephone call was after the writs had been served, but probably prior to the statements of claim, is that right?
Well, certainly after the writs and prior to the defence, because the writs were served with general endorsements with statement of claims following later, I can't now say when within that period it occurred. And the note's not dated, which is unusual for me, and I don't know why it's not, but it's not.
Now, if we have a look at perhaps the statement of claim in relation to Emma Foster as an example, that's at tab 182, and it is, as I indicated earlier, the amended statement of claim. see that the defendants are described as Noreen, Harrison and others, according to the schedule attached. And unfortunately, in the version of each of the statements of claim that we have in the bundle, there isn't a schedule attached. So the first thing perhaps we need to do is just identify who the defendants were. So starting with the first defendant, if we can go to page 4, paragraph 2. First named defendant during the period was the school principal of the school. So that was Noreen Harrison.
Yes.
And on the next page, paragraph 3, the second named defendant is said to be an emeritus Archbishop of the diocese.
Been Archbishop Little.
Yes. And on page 6, paragraph 4, the third named defendant is the Catholic Archbishop of the Diocese of Melbourne. That would have been Archbishop Hart.
Yes.
And the fourth defendant on page 8, paragraph 5, said to have been at all times material, and in particular during the period, a body corporate pursuant to the Roman Catholic Trusts Act and so on. So that was the Roman Catholic Trusts Corporation for the Archdiocese of Melbourne, is that right?
I think it's called for the Diocese of Melbourne, yes.
And then on the next page, the fifth named defendant, at all times material, and in particular during the period, was an ordained priest of the Roman Catholic Church, incardinated in the Diocese of Melbourne. He was attached to various parishes throughout the Diocese of Melbourne, and in or about 1992 was the Vicar General for the Diocese of Melbourne, and that was Reverend Father Hilton Deacon, is that right?
That was Bishop Hilton Deacon, yes.
And the sixth defendant on page 12, paragraph 7, was also an ordained priest of the Roman Catholic Church, incardinated in the, as it's called, Diocese of Melbourne, and he was attached to various parishes and so on. That was Father Anthony Gulen, is that right?
Yes, I recall that's correct.
Now, if we can go to page 18. I'm sorry, perhaps we should start at page 17. And before I go into it, it's the case, isn't it, that the generally speaking, the statements of claim replicate each other insofar as the allegations are concerned, with regard to the abuse itself, and then as to who had what knowledge and involvement.
Yes, and was a distinction between, on the one hand, the pleadings on behalf of Emma and Katie as primary victims, and the other members of the family as secondary victims.
Yes.
But otherwise, yes.
And scroll up just slightly. So it says that the plaintiff, here we're dealing with Emma, of course, suffered and continues to suffer above-mentioned injuries, loss and damage as a consequence of the breach by the defendants of their duties referred to in paragraphs 9 and 10. And then it has particulars of breach. And if we can scroll down and into the next page, it has what's referred to as particulars of knowledge. And then, in particular, if we can look at subparagraph Roman 3, in or about 1958, it said complaints were made by a Mr. and it's redacted, and Mr. someone else redacted, in respect of the interference by the deceased, that was Kevin O'Donnell, yes. O'Donnell, I beg your pardon, with a young boy.
Yes.
Such complaints were made to Monsignor Lawrence Moran, the then Chief Administrator for the Diocese of Melbourne, and then it's defined as the 1958 complaints. Do you see that?
I do.
So I'm identifying then there were 1958 complaints, and I'll go and identify each of the others.
Yes.
If we scroll down further, it said that subsequent to the 1958 complaints, Mr., and it's once again redacted, once more complained to a priest at St. Francis Church, Melbourne, in the Diocese of Melbourne, as to the inappropriate behaviour of the deceased towards infants, and that's referred to as the St. Francis complaints. And then in 5, in early 1992, Reverend Father John Silvano complained to the fifth named defendant, that's, I think you said Bishop Deakin, about the inappropriate behaviour of the deceased with young children. The Silvano complaints. Now, those are then given some further details. We can look at page 23. There's a heading which says particulars of breach of duty by the fourth named defendant, as alleged in paragraph 10 hereof. The fourth named defendant was, of course, the Trusts Corporation.
Yes.
And then below that, particulars of breach of duty of the fifth named defendant. That was Bishop Deakin, and it says, failing to act upon complaints made by Father John Silvano in early 1992 in respect of the inappropriate behaviour of the deceased towards young children. And then if we look over the page, the particulars of duty of the sixth named defendant, that's Father Gulen, failing to act upon his observations of the deceased engaged in inappropriate behaviour with the young boy whilst in the Diocese of Melbourne in or about 1958.
Yes.
Now, as solicitor for these 6 defendants, you were then involved in investigating the factual basis for these allegations and the statements of claim, is that right?
Yes.
And at tab 189, there's a file note of yours in relation to a discussion or a couple of discussions. We can look at the retyped version on the next page.
Yes.
And can you just explain briefly what is the first reference there with regard to Kevin Lyons?
The Lyons was junior counsel, briefed with David Collins, SC, to draft the defences for the for the defendants.
And you had a conversation with him?
Yes, yes.
And
I
this-
briefed him and I had a conversation with him.
And this is a brief note of your conversation with him?
Yes,
Or shall I say taken during your conversation with him?
yes.
And where it says Gulen, where does he fit in? Was he, I take it that's parish priest?
I have no recollection, I have to say, of these conversations from 10 years ago, but I would be confident that PP is parish priest, yes.
Yes. And then it would appear then to be a subsequent conversation on the 30th of November, T/F PJOC, I take it a telephone conversation between you and Mr. Callahan.
Yes.
And can you explain, with reference to your note, to remind you what the substance of that conversation was?
I can, but there's a bit of background that I probably need to give in order to, given that I have no recollection of the conversation, in order to give you my best interpretation of it. There's a little background that I need to give, and the background is that some years prior to, we're in, what year are we now, to 2004, I think, some years prior,
This is November 2004, this
Thank you.
phone call.
Yes, so some years prior, in the late 1990s, I had been acting for various defendants associated with the church in other proceedings issued by victims of O'Donnell, and relevantly in particular, a proceeding issued by a person whose name is redacted in that diary note. And in that proceeding, similar allegations were ultimately made, by which I mean made in amended versions of the pleading, in relation to Father Goulin having witnessed O'Donnell abusing a boy. And my best recollection is that when I received the statements of claim from the Fosters, I had a recollection of having seen that allegation before, and I had a recollection also that the plaintiff whose name is redacted was one of the complainants in the criminal prosecution of O'Donnell. I can't be sure whether I recollected that then, but I now know that to be the case. I think I recollected that then as well. So that was the context in which, but at the time, I think I could not remember, either I couldn't remember I couldn't remember the name of the redacted person, or I had some confusion as to the dates and how it all fitted together. That's my best recollection of where I was. So I phoned Peter O'Callaghan.
For assistance, to remember.
For assistance, yes.
Just on a point of accuracy, as I understand it from documents that I was given by those instructing you this morning, that if it's the same case you're referring to, that the plaintiff in the case was someone else, not
Yes.
the person who said that Father Goulin had walked in on Kevin O'Donnell and that person.
That's so. So it was Mr. Redacted, if I can call him that, Mr. Redacted, who had alleged that Goulin had walked in on O'Donnell, and in a separate proceeding which had been issued with a pseudonym, so I think I'm safe to pseudonym, of ID, Mr. ID was, in the same way as the Fosters were seeking to do, Mr. ID was seeking to rely on the allegation that Father Goulin had witnessed O'Donnell abusing Mr. Redacted as evidence of prior knowledge.
And information that Mr. O'Callaghan was able to disclose to you assisted you to recollect the matters you've described.
Well, it appears from the diary note that that is the case, yes.
And your statement dealing with this, you will recall, in its original form said that Mr. O'Callaghan advised you of matters of which you had not previously been aware, and in correcting the statement at the commencement of your evidence, you changed that to matters of which you didn't recollect, in other words, didn't recollect at the time of the phone call.
That's so, and also didn't recollect at the time of making my statement.
Yes.
Yes. So, while I don't... I'm sorry, Your Honour.
You finish.
Oh, thank you, Your Honour. While I don't have any recollection of this conversation at all, what I can say is that from time to time I contact Mr. O'Callaghan seeking information from him, and that I'm very mindful of the fact that there's information that he has as Independent Commissioner that is confidential and that it's inappropriate for him to tell me, but also that there's information that he has from other sources that he can tell me. And as I think this entire discussion demonstrates, my memory is not as good as his. Mr. O'Callaghan, in my experience, has an excellent memory, and I knew also that Mr. O'Callaghan had studied in some detail the criminal prosecution of O'Donnell, as well as the criminal prosecution of other priests who had been prosecuted. So, in a context such as this, where I was acting as solicitor for the Archbishop and others, and I had a statement of claim in front of me that I was seeking to respond to, I would have told Mr O'Callaghan why I was ringing and the purpose for which I was asking him questions, and I would have asked him whether there was anything that he could tell me, or words to that effect.
Mr Leader, you've been involved in this work for the Church for a long time.
Yes.
And we understand the work that you've done in a general sense. I presume that over that time you've had many discussions with archbishops, bishops, vicars general, priests and so on about pedophile activity within the Church.
Yes.
And in those discussions, I assume the topic of what the Church might have known or understood has been raised on many occasions.
Yes.
Is that right?
Yes, it is.
Now, those outside the Church have some understanding of the way the Church operates and the way priests are accommodated, and no doubt meet on a regular basis with each other, both socially and for professional reasons. Would that be right?
I'm sure that's so, yes.
Well, have you not learnt of that in your discussions about the Church and the way it operates?
I think I have learnt of that, yes.
Yeah. Now, in the discussions that you've had when you first started this work, I assume you spoke with the Archbishop about pedophile activity within the Church?
I'm sure that I must have had some discussions. You're asking me about when I started, so you're asking me about Archbishop Little, and I'm sure that when I started I would have had a discussion or two with him, but at that time I was a relatively junior solicitor and I didn't have a lot of direct contact with Archbishop Little.
You're older and greyer now, but nevertheless you were being called in, as it were, with your firm to advise the Church in relation to this problem.
Well, my firm was there and I became involved, yes.
And the central issue is pedophilic activity within the Church, wasn't
Yes.
it? Now, you say you had or involved in some discussions with Archbishop Little about the matter?
I'm sure that I was, yes.
Now, were you involved in discussions with him about what he might have known about pedophile activity within the Church?
I certainly was involved in those discussions in relation to O'Donnell.
What about others?
Undoubtedly, yes. Most likely in the context of other litigation. In other words, litigation in relation to priests other than O'Donnell.
What about apart from litigation, just as a general issue? Now it was emerging, public knowledge was coming along.
I don't believe that I had those discussions with Archbishop Little. As best as I can remember, I don't remember any general discussions with Archbishop.
What discussions did you have with Archbishop Little about Father O'Donnell?
In a proceeding which was neither the proceeding issued, well, in a proceeding brought by a victim of O'Donnell, which was neither the proceeding brought by Mr Redacted, if I can call him that, or by Mr ID, but by someone else who issued proceedings under the pseudonym SP, the proceedings reached a point at which Archbishop Little was required to answer interrogatories. And I had various discussions with him in order to take instructions for the drafting of the answers to interrogatories. So I can point to that context quite specifically as an occasion where I did have detailed discussions with Archbishop Little. And
I assume the interrogatory was asking him, amongst other things, whether he knew.
When he knew. Yes.
What was his answer?
His answer was that he had no knowledge of any activity on behalf of O'Donnell until 1992.
And what did he know in 1992?
What he knew was the complaints brought forward by Mr Redacted. In other words, in 1992, if I have all of these people right. Certainly in 1992, a victim came forward to the then Vicar General, Monsignor Cudmore, complaining about O'Donnell.
And the Archbishop was told.
Yes.
What did the Archbishop do about it?
I'm sorry, Your Honour, I've said 1992, I need to correct myself, it's 1994. And at that time, O'Donnell was already retired.
So, your evidence is that it was in 1994 that the complaint came forward?
Yes, I think so. Certainly, I'm slightly hesitant as to dates, and I'd be grateful for the opportunity to refresh my memory on these matters, but certainly that Archbishop Little had no knowledge of any complaint by O'Donnell until after O'Donnell had retired. That was the central point of the interrogatory and the answer.
Right. Now, Archbishop Little retired in 1996?
Yes, in 1996.
One of his auxiliary or assistant bishops for some time had been, as he then was, Bishop Pell.
Yes.
And I assume you've had discussions with Bishop Pell about his knowledge of pedophile activity within the church, is that right?
I have.
And those discussions, did they start before he became the Archbishop?
They started after after his appointment as Archbishop was announced. It's in late July 1996, but before he was formally appointed.
And
I had not known him I apologise, I had not known him at all as a bishop.
And I assume that you had discussions with him in relation to the Foster's allegations.
Yes.
That's right. And as you know, as the Cardinal's knowledge of pedophile activity within the church during his time as Bishop and Archbishop in Melbourne.
Yes.
And did those discussions range to the general question of knowledge of pedophile activity within the Archdiocese?
Yes.
And can you recall those discussions now?
I can recall I don't recall specific discussions.
Can you recall the general content?
Yes.
And when did those discussions start?
In July 1996, when we were discussing what became the introduction of what became the Melbourne response.
And what did the Cardinal tell you as to his knowledge of pedophile activity within the Archdiocese?
The Cardinal was aware of prosecutions that had occurred, particularly by that time, of course, O'Donnell and Glennon and others. He was aware of that. He also told me, and I had some detailed discussions with him on these matters, that he had no knowledge of any other activity. He had no knowledge of activity that had not been acted on, but that it was his general impression that that had occurred within the church, and that one of the reasons for the establishment of the Melbourne response was to deal with that.
And in terms of his knowledge of what had happened, do you say that was confined to becoming aware of it when priests were prosecuted?
Yes, or that allegations became known somehow publicly. I have a clear recollection that what he told me was that he only knew about these allegations as they became public.
Yes, very well.
Thank you, Your Honour. Returning to the note that's on the screen, and I take it at the foot of the page where it's TT Kevin, you phoned Kevin Lyons, you advised him of what you'd learned, he said David Collins is looking at it all and that you would fax or email the details. Is that right?
Yes.
That's the sum of it, really.
Yes.
Right, if we look at tab 190, this is now, as I understand it, your promised fax with the details.
Yes. Sir, could we go back to the diary note?
Yes, of course, that's the previous tab.
What the diary note says is that someone walked in and Mr. Redacted was with Kevin O'Donnell, and the dash denied, I understand to be a reference to Father Gulen denying that the allegation that he had walked in on O'Donnell with a boy. And it goes on to say that after that, the Scoutmaster went to the cathedral. But in looking at this diary note, I can see that that is not consistent with my understanding of the chronology, because my understanding of the chronology is that the Scoutmaster went to the cathedral in 1958, and that it's in 1962 that Gulen allegedly witnessed O'Donnell with the boy. So I can't. What I wanted to say about that diary note is that I don't believe that that's recording anything that Mr. O'Callaghan told me, because the chronology doesn't make sense. I think most likely it's a reflection of the fact that in the statement of claim, the allegation about Gulen was said to have been in 1958, and that's not right, and I think because it was 1962, and that was what was in part confusing me.
Well, let's take a look at what you then advised counsel who were tasked with drafting defences in these actions, because that might clear it up to some degree.
Yes.
We can scroll down. So you say in the first paragraph you have a little further information on the sixth defendant, Father Gulen.
Yes.
And then you set it out, he is a priest and he is in good standing. The relevant allegation against him appears to be that, according to the police statement of an O'Donnell victim, and it's redacted in 1962, Gulen, would you understand that, was called by O'Donnell, I beg your pardon, the redacted person was called by O'Donnell into O'Donnell's bedroom. I'm going to get the unredacted one so I can be sure not to be misleading you, Mr. Leader. Yes, that's right. So victim A, we might call him, was called by O'Donnell into O'Donnell's bedroom. O'Donnell was in bed and pulled back the covers. O'Donnell was wearing pajamas, and he pulled that person A into the bed on top of him. The door opened and Father Gulen walked in. O'Donnell pushed A away. Gulen left. I'm informed of the aforegoing by Peter O'Callaghan.
Yes.
Right. And there's no indication there, of course, that you knew that information from any other source.
I did know that information from another source, and I know that positively because in the ID proceeding, as I said before, the same allegation had been made, not initially. What occurred was that Mr. ID had issued his writ, and there were, over a significant number of months in 1998, various applications seeking leave to amend the statement of claim. And in support of the application to amend the statement of claim to include what I might call this 1962 Gulen allegation, Mr. ID's solicitor swore an affidavit in support, and he exhibited to that affidavit the police statement of Mr. Redacted.
Yes, and that's the one I referred to earlier. That's what I have, yes.
Yes, and I'm able to say that I had that police statement as a result of it having been exhibited to the affidavit in support, which was tendered in court, and I had that police statement. I had clearly forgotten about that when I spoke with Mr O'Callaghan, and my best recollection is that my conversation with Mr O'Callaghan assisted me in sorting out the confusion about 1958 and 1962, and I suspect sorting out the confusion between the identity of Mr Redacted and Mr ID, and ultimately allowing me to go back to my file in relation to ID, find the affidavit in support and the police statement on it, and I can say with some confidence that I must have had the police statement in front of me when I drafted that fax, because the fax contains details that aren't recorded in my diary note with Mr O'Callaghan. And I believe in any event that I would not have prepared a fax to counsel giving instructions about those details without referring to some document.
And you go on to say that I have ascertained Gulen was the assistant parish priest to O'Donnell at the time.
I also say, sir, at the end of the paragraph that we were talking about, I'm informed of the foregoing by Peter O'Callaghan. And, Your Honour, I don't believe that I was informed of all of the matters in that paragraph by Mr O'Callaghan specifically. I believe that I must have been informed by Mr O'Callaghan that Gulen was a priest in good standing, and I believe that the source of my information for the rest of the paragraph was the police statement, which I already had, but which I had been unable to locate until Mr O'Callaghan was able to, as best as I recall, give me some information that allowed me to know which file to go and look for it on.
Well, this is your present reconstruction of what you think occurred at the time.
Yes, it is.
Because, firstly, you've said Mr Callaghan has a very good memory.
Yes.
And that would include a memory for detail, I take it.
Yes.
And secondly, you wrote this fax very shortly after, in fact, as I understand it, the very same day that you spoke to Mr O'Callaghan.
Yes.
And so had he given you the detail that appears in this paragraph, you might still have been able to record it in a fax in that.
Yes, it's possible that I did. I'm now able to say that I already had the information in a police statement, which was the exhibit referred to, although plainly I did not recall that earlier on the 30th of November, or I wouldn't have needed to talk to Mr O'Callaghan about it.
Yes. Or indeed when you prepared your statement for this hearing.
That's correct.
You say, or you proffer the proposition, a couple of paragraphs down of itself, none of this would seem to implicate Gulen, unless it could be said he saw something, had a duty to report and breached that duty.
Yes, on reflection, plainly if he saw something he would have had a duty. Of course he would have.
Yes, of course he would have. Yeah. So just so we all understand, the information you had was that he had seen something. Is that right?
No, the information I had was that Mr Redacted had given a statement to the police saying that he had, yeah. But the other information that I had was that at the time that had been alleged in the ID proceeding, I had somehow become aware, probably by talking to Father Gulen, that he absolutely denied the allegation.
And Mr. Leader, those representing you advised of your wish to amend your statement on this question, in other words, of whether it was knowledge you acquired from Mr. O'Callaghan or whether it was just recollection that you acquired after Mr. O'Callaghan had given evidence on this point, is it not?
Yes, the amendment that I have sought to make is that in paragraph 115 I had initially said that initially I did not know the details of the history or relationship between O'Donnell and Father Gulen. But I now realise that that must have been incorrect because I had knowledge from the ID proceeding, which I had forgotten when preparing this statement.
Yes.
What I mean to say is at the time that I was preparing the defences in the Foster's litigation, I had knowledge from some 6 years previously.
And it was listening to Mr. Callahan's evidence that when that occurred to you?
It was not so much listening to Mr. O'Callaghan's evidence as reflecting on the diary note, I think.
Your Honour, would that be a convenient time?
Yes, we'll take lunch.